Good afternoon, everyone, again. I guess we can start now. First of all, thank you very much, all of you, for joining us to discuss the political ads regulation and different aspects of it. First of all, before I forget, this session is being recorded. So I guess if you speak in a microphone, you are consenting to being recorded, and the recording will be published and disseminated. So first of all, that. Second, just trying to be very quick before introducing the speakers, who have certainly much more to say than I do on this discussion. There are two reasons why we wanted to throw this event. First, we do believe that the political ads file remains to an extent under-discussed. It's a file with a relatively narrow scope of application, etc. There are some good reasons for that, but at the very same time, there are, I believe, good reasons why it actually merits a lot of discussion, not least because in the current political negotiations on the file are featuring the possibility of approaching data protection from innovative and novel manners that could be extended to different future political initiatives. And second, because it may, and this is the main objective of the session, it may represent a different paradigm approach to the regulation of data protection in the EU. So that is the question that I would be hoping that we would be addressing by the end. Joining me in the panel, we have speaking first Eliška Pírková from Access Now, second Maria-Manuel Leitão-Marques, who's shadow rapporteur in the main committee in IMCO in Parliament, then Colaps from the EDPS cabinet, and last but not least, Asha from Center for Democracy and Technology EU office. So without further ado, I would like to ask you, Eliška, to contextualize a little bit this file. What do we have in a file that is currently in trilogues? So for those of you not that familiar with EU policymaking process, that it's in the phase of reconciliation and negotiation between Council and European Parliament. What is in there in the political ads file from a data protection point of view in terms of substantial rules and enforcement?
Thank you very much. It's a great pleasure to be here today. For those who are not familiar with the organization Access Now, we are a global human rights organization that defends and extends rights of online users at risk around the world. And our Brussels team is working on all legislative files and dossiers here in Brussels that touch upon the issues of protection of digital rights or human rights in online ecosystem. And I'm not sure whether it's the blessing or the curse to be a first speaker, but I'm going to do my best to walk you through these rather complicated file that we've been working on together in the coalition with civil societies that are present here today from its very launch. So first of all, the goal or the regulatory goal and purpose of the regulation is to establish more transparency and also to avoid abusive practices, especially when it comes to the use of user-sensitive data in targeting for the purpose of political advertising, as well as for the purpose of so-called ad delivery techniques, who are highly automated, often black boxed, and it's extremely difficult to establish any meaningful transparency for you as individual users to understand why you see certain advertisement or why you're being targeted for that purpose. As a digital rights organization, we are mainly focusing on three areas. First of all, it's the way how political advertising is being defined by this regulation, and my colleague Asha will go into the details, so I will skip that topic for today. The second point is definitely the way how our sensitive data are being used for the purpose of targeting as well as for the purpose of the ad delivery technique. And the third point would be the enforcement, because as we know, no matter how good legal text we have on the paper, if the enforcement is not powerful enough and not meaningful enough, then the law doesn't meet its mark and it remains largely ineffective. So first, the text of the proposed regulation currently in the final stages of the legislative negotiations suggests that the targeting of political advertising could involve the processing of special categories of data if individuals provide their explicit consent. This was initially proposed by the text of the Commission, and we've been very critical of these measures from the start. Many of those shortcomings in the original text were fixed in the position of the European Parliament that we, to a large extent, support. But however, the way how the negotiations are currently proceeding, also reflecting on the general approach of the Council of the EU, our concerns remain. This is for the reason that this position would undermine the proposal's fundamental objective to actually increase the integrity of elections and to ensure that the people's freedom of opinion will be protected without any further manipulation, and consequently that will result in strengthening the democracy in Europe. It would also breach already existing horizontal legal framework, the Digital Services Act, that directly contain the ban on the use of sensitive categories of data in targeting and for profiling, concretely in Article 26. And it's very questionable whether the express legal basis, that means explicit consent for the use of these data under the GDPR, would actually suffice when we speak about the protection of our democracies and electoral integrity. Since the launch of these regulations, together in coalition with our partners, we were strongly defending the strong Article 12 that would actually contain a proper ban on the use of sensitive data without any exception of explicit consent, and also the ban on the so-called observed and inferred data, more specifically in the case of ad delivery techniques. To a large extent, we managed to defend this position, especially in the context of European Parliament. And why this is such a huge priority for us, it's mainly because the automated ad delivery technique processes enormous amounts of data and help from predictions of what messaging is most relevant for targeted individuals. And of course, these techniques very much exploit individuals' vulnerabilities. It follows the hidden patterns in individual online behavior, and it derives personal data that individuals did not consciously or voluntarily disclose. And as we know, the European Data Protection Board guidelines rightly explains that the processing of large amounts of personal data for the purpose of targeting and ad delivery techniques puts the rights and freedoms of individuals at risk. Hence, this existing ban that currently is incorporated in the position of the European Parliament is essential for the protection of individuals and groups' fundamental rights, and we will continue fighting that it will remain intact until the final text is being adopted. Going quickly, just touching up on the enforcement, because I know I'm running out of time. The current text of the regulation, again, especially in the version of the European Parliament, is looking in the empowerment of the European Data Protection Board. So under these measures, the European Data Protection Board would be able to initiate its own investigation in case of violations of Article 12 that hopefully will contain the ban on the use of sensitive data for the purpose of targeting. And especially if these violation occurs on very large online platforms or by very large online search engines. We very much support the empowerment of the European Data Protection Board, and since Access Now has been actively working on the issue of data protection and also enforcement of the GDPR, we are well aware of what it means when regulatory authorities do not have enough resources and expertise or other means to actually properly enforce the regulation. For us, the EDPB could play a crucial role, especially when it comes to cross-border cases, learning from the previous mistakes that we often observe when it comes to the rather ineffective or not so strong enforcement of the GDPR regulatory framework. I'll stop there and I look forward to further debate. Thank you.
Thank you very much, Eliška. Picking up from there, maybe I wanted to ask MEP Leitão-Marques to cover the other aspects of the regulation just for presentation beyond the data protection aspect that Eliška was covering.
Thank you very much and good afternoon to everyone. And I'm starting by thanking the EPD and in particular Fernando for putting this panel together. As Eliška just described, this regulation really has the potential to bring forward a new paradigm for data protection and not just in the context of political advertising. I believe you have a unique opportunity to show that advertising, and in particular online advertising, can take place without the current risks to the fundamental right of privacy. And I'm hopeful that the concept of inferred and observed data in particular will be adopted in the final texts. However, our priority should be protecting people more than protecting data, and in that case, protecting democracy and space for healthy public debate. That is a problem nowadays for our democracy for many reasons, and with some bad examples we have from the past. That is why I'd like to focus my intervention on transparency provisions of the regulation and how they are crucial to monitor its enforcement. The proposal has plenty new rules on transparency. To cut in short, there will be an increase in the information available to the public and authorities on who is sponsoring political ads, who is financing them, where the funding is coming from, among other aspects. But from the point of view of voters, ourselves, which are the tools that will translate into increased transparency? And I would like to refer to special one of them. The first is label placed on or next to every political ad that identifies the ad as political and as basic information on the sponsor. It works on the basis of the increased awareness of each viewer of an ad. The other tool I would like to mention, and from my point of view is more important and impactful, is the European Repository for Online Political Advertising. For every single online political ad in Europe, in the European Union of course, accessible to everyone, free of charge, and with information updated in close real time. This idea is not new. We all remember the discussion in the essay, which culminated in an obligation only for very large platforms to make public available a repository on their ads. And the signatories of the Code of Practice of Disinformation have also committed to setting up repositories for political and issues-based ads with certain characteristics and with access for researchers via APIs. However, this new repository, as proposed by European Parliament, let's see the final result, has several benefits. First, contrary to the Code of Practice or the essay, it will be comprehensive, including all political ads online and not just those published by very large platforms or other signatories voluntarily of the Code of Practice. Contrary to the existing repositories, it will be much more user-friendly, allowing a single point of access to all online political ads and not requiring multiple searches in several different repositories. And in addition to what is available in present-day repositories, this new one will be more detailed in demanding specific information to be available, expanding the potential for researchers to test their hypotheses and to increase knowledge about political change and political advertising, of course. But what is the interplay between the repository and data protection, the topic of our panel? And where does the protection of people and democracies come in? Let's think back to the reasons that make us tighten the data protection rules for political advertising. And I will highlight two of them. The first is micro-targeting of voters with consequences on the type of message that are put forward by political actors. And the second is the exploitation of the vulnerabilities of voters and consequent manipulation of their choices. And we remember Brexit referendum. This happened not only through targeting, but also through ad delivery, the sort of second step targeting done by platforms, predicting engagement with the potential target audience to deliver the ad to those most likely to interact, view, click, or whatever the relevant metric is. All this reinforces the importance of the data protection provisions described before. But how do we ensure that are being enforced? How can we study the impact, the effective impact of this regulation? How can we see if additional measures are still needed? This will all be answered by the research coming out of the repository. So the repository is fundamental for the enforcement, for the effective enforcement of this regulation. Think about the papers done by Sapienski and his colleagues, measure discrimination and other harms arising from the ad delivery algorithms, in particular Facebook. As he has explained to us in a public hearing in the Parliament, he does this research despite the poor availability of data from platforms. Yes, repositories already exist, but do not contain enough information. The Parliament proposed to make available details, such as the specific groups of individuals targeted, the categories and sources of personal data used for targeting, and the reach of the political ad, the number of views and engagement with the advertising. It could be even better if you had separate information on data used for targeting and for ad delivery as requested by Piotr, but unfortunately that was not political possible. Thus, the repositories are not only a transparency tool to look at the message propagated in campaigns or the sources of financing, but in fact they will be a cornerstone for the scrutiny of data protection measures relating to political advertising. I expect your support for the Parliament position, because we need your support, and in particular for this point. It's perhaps the most important part of it, because it will allow us to find out if, on the top of having a good law in books, we will have good law in action. That is our main purpose. And to adjust the level of protection we hold our citizens accordingly. Thank you for your attention.
Muito obrigado, MEP Leitão-Marques. I particularly bear in mind from your point at a moment when the consultation on access to data is still open, the very point on access for free, without charge, at a moment when it's a very specific VLOP is expecting researchers to pay quite a lot to access some basic data. And on this note, I wanted to invite Mrs. Colaps to comment out of these relatively more ambitious measures vis-à-vis the original Commission proposal. Some advocates of a less ambitious political advertising file in the area of data protection have argued that going for restrictions on which type of personal data may be used in political advertising for restricting it based on how the data has been obtained, so treating tracking-based personal data in different ways to other personal data proactively provided, that this represents a change of paradigm from the GDPR that is just too large, that is just lex specialis departing too much from the general data protection regulation. So on this note, I wanted to invite you to comment on the extent to which, for instance, the DSA and the DMA might be in between GDPR and political ads regulation in terms of paradigm, or what paradigm do we need today to protect personal data of Europeans and ultimately to protect them?
Thanks a lot. Just checking that you hear me well. I'll get it closer. Well, I should start by thanking you all for coming to this session, and thanks, of course, to our moderator for the invite. I'll start by saying that privacy and data protection are not only end in themselves. We would grasp their full potential if we appreciate and value the instrumental role that they have in our society to achieve protection of other fundamental rights relevant for today's topic, freedom of expression and our civic engagement. So this is why I think that the participation of privacy experts in this debate in relation to the political advertising file is so crucial. And it's also a broader example, is yet another example of our broader engagement as EDPS on how to show how to apply privacy and data protection to the most pressing public policy concerns, because this is what we are talking about. We have seen that the misuses of personal data have led to online manipulation, and have led to distortion of our democratic processes. And so by using data in a fair way, and by that I not only mean the adherence to the words of the GDPR to ensure compliance, by that I mean adherence to the spirit, the soul, of principles and rules that represent a whole set of civic rights, such as privacy, in fact. Only by doing that, by ensuring a fair treatment of personal data, we achieve in once two very important public interest objectives. We protect people from manipulation, we protect their dignity, and we defend our democratic system. So it's about protection. I want to be clear, just not to be misunderstood. Of course, GDPR is a pillar of this protection. It's the pillar of protection of people when it comes to their personal data and much more. But I think it's a baseline. So nothing prevents the legislator, the co-legislator, to go beyond GDPR. And by doing that, I mean to do better, even if possible, if something better can be done. And I think that, so this going beyond, this extending the protection, this adding even on top of GDPR, is what is exactly happening with some provisions in some legal acts that the European legislator has adopted or is in the process of adopting. What I basically call, I don't know if any other call them that way, but the acts of new generation, basically. And so DMA, DSA, the Artificial Intelligence Act. It's true, they differ from the GDPR approach. But I wanted to make clear what I mean here by paradigm shift, because recently, in these past days, I've heard many interpretations of what a paradigm shift may mean. So to me, while GDPR sets, we heard that in the past, the rules of the road, so determines the frame for the controller, the processor, or the players involved to safely lead the journey, these new acts actually are much more explicit on determining what is acceptable and not acceptable in our society. So whether certain practices should have at all a place in our society. And that's a very interesting approach. I'll give some examples. Is it appropriate at all that religious beliefs, very sensitive data, are used for targeted advertising in a political communication context. Or, for example, a discussion that is happening in the context of the Artificial Intelligence Act is whether we should allow for data on sex life or sexual orientation to be used for training algorithms in order to fight and prevent bias and discrimination, which is, of course, a very noble aim and objective, but it's not an easy one. So this is the type of debate we are having. Let's not forget that these new acts, the DMA, Fernando, the DSA that you were also mentioning in your initial remark, contain, at least this is my opinion, data protection provisions. They do contain data protection provisions, and Article 12 in the political advertising regulation is a data protection provision, which will be enforced, hopefully, by data protection authorities. This is not me saying that. This has been the choice of the Commission, who chose Article 16 of the Treaty on the Functioning of the European Union as a legal basis, in addition to the harmonization legal basis of Article 114 of the Treaty, to base this legislation. And as we know from the Court of Justice, Article 16 is the appropriate legal basis whenever the protection of personal data is one of the essential components of the new rules. So there are data protection provisions out there. We should not be afraid of saying that, I think, even in the privacy community. Let's face the reality. In DSA, this is the case at least for Article 25, 26, and 28, so respectively dark patterns, target advertising, and targeting of minors' data. But I think it's also the case for DMA. Article 5 is a data protection provision going against the undue combination of data sets, and even the Artificial Intelligence Act will have a data protection provision, at least in Article 5, with its intention of limiting, or as we hope at EDPS, prohibiting, in fact, the real-time biometric traits collection in publicly accessible spaces. So I like the title of this panel. I think the title of this panel feels quite just right, data protection in political advertising. So my point is, the reality that we should be aware of and not afraid of and not shy away from is that data protection, in fact, in the near future, I think, will not be only defined by the GDPR. Will, in fact, be also defined by these new provisions, which will concur, in addition to the GDPR, on top of GDPR, to define what privacy and data protection is in practice. There will be frictions. Let's be clear. Let's face the challenge. Frictions coming to name just one aspect from the fact that definitions and situations are not properly aligned. For example, in relation to the political advertising file, we said, well, let's pay attention to the responsibility of publisher and political sponsors, because they can be jointly responsible and joint responsible under a data protection framework. But yet, these practices, these provisions, these acts will contribute to shape, even with their fallacies, what is data protection in practice. So will contribute to shape the relevant environment which is applicable to data practices. This will be one of the main challenges for data protection authorities, which will need to evolve and adjust in a modern way if they want to survive. So to conclude, there's no harm per se, I think, in going beyond GDPR if we want to do better. This is an important point. If we're talking about seizing a legislative opportunity to increase the protection in respect of what we have. So if we want to extend such protection, the protection of the GDPR, and the way we understood it at the EDPS is that, of course, the intention of this regulation is to extend the protection. So let's make it. Let's make it happen. Let's make it happen properly. Because the impact of possible continuation of misuses in this field on rights and freedoms will be huge. And of course, the debate on which I look forward to contributing maybe later, it's also about the potential extent of prohibition. So you named a few, sensitive data, yes or not, or inferred unobserved data. So I'd like to contribute to that as well. Whenever in doubt, and I'll conclude by that, I think we should really get back to the original role that privacy and data protection was intended to play in our society. And that is protecting people, protecting people's dignity, protecting people free self-determination. This should guide really any reflections, including legislative reflections, on what we can consider fair and acceptable in our society. Thank you.
Thank you very, very much, Anna. Zooming out from there, probably, but on the note of data protection serving to protect people, to protect their fundamental rights, to protect their political rights, to protect their dignity, I would like to pass it to Asha to discuss how can this regulation protect personal data rights at the same time that, well, its very nature, a very political one, how this can interact with the protection of rights such as freedom of assembly, freedom of association, freedom of expression, right to information, etc. Floor is yours.
Thank you. Can you hear me? You can hear me, right? There's no problem. Yeah, I'm loud enough as it is. Great. So thank you so much, and I really appreciate the brilliant inputs from my fellow panelists, and I'd really like to follow on from what you just said there, Anna, in regards to the ongoing conversations about improving those protections, because I have a concern that they're doing the reverse and decreasing those protections of GDPR, undermining the provisions that you mentioned already, and from the perspective I'm speaking of, when you capture that in a very specific framing, they're posing risks to fundamental rights, just as you mentioned, on freedom of expression. And so are we looking at a negative paradigm shift is the question that I would pose, thinking about these conversations. But the misuse of personal data, special category or otherwise, which in itself is an abuse of the fundamental right of data protection, has clearly led to tangible examples of risks being posed to freedom of expression, or the right to relevant information in an election context, which is part of the international human rights framework as well. And as you can probably hear from my accent, I'm a Brexit escapee. This is very personal to me and the outcomes that come from certain situations. So the interplay between these rights actually under the Charter are inextricably linked from our perspective. And so what I would say, for an organisation like ours, and for those of you who aren't familiar with CDT, we're a not-for-profit organisation who focuses on advocating for the preservation of human rights in EU digital tech policy. And so what's been underpinning our advocacy engagement on this particular file has been the need to ensure that the scope and indeed the intent of the regulation is crystal clear. A lot of these provisions on data protection actually take on a very different characteristic depending on how broad of a scope or how narrow of a scope that the regulation actually is. And I've spoken about this regulation several times, and I always start on this particular point. This regulation to address political advertising is very much needed, of course. The current status quo when it comes to online political advertising and that environment is one of obscurity. But this is not a regulation about addressing disinformation or the virality of user-generated content that is neither sponsored nor promoted content, but that can have an impact. This is a regulation about political advertising, but I'm sure you all know that already. But there are many brilliant civil society colleagues providing expertise in the development or implementation of existing legislative or voluntary frameworks aimed at addressing issues such as disinformation. So it's important that these issues are addressed in the appropriate forum and not indirectly. But to come back to the regulation itself, unfortunately, Article 2, as drafted by the European Commission, which includes the definition on political advertising, very much needed to be narrowed, because the proposal, unfortunately, mischaracterized political speech on elections or political processes by individuals as if they were forms of political advertising, which they simply are not. And this poses a huge risk to freedom of expression for several reasons. First, we must remember that under extensive jurisprudence, political speech is the most protected form of free expression. And so any restriction of this must meet international human rights standards. However, I'd like to imagine this practically. If all forms of political speech, so let's say non-commercial political speech, could potentially be classified as political advertising, in the case of online platforms, in order to ensure compliance, they will need to ascertain which examples of this non-commercial political content may fall under this definition and may need to have the related obligations apply. Platforms should absolutely not be making this determination. And the idea undermines the key purpose of the regulation itself, which should be to curb the power and the influence on the online advertising ecosystem in this particular regard. So quite simply, political advertising in the online sphere is, as been reiterated by many civil society organizations, paid for or sponsored content. And it is the most appropriate scope for the definition to ensure the necessary safeguards for political speech. We see very strong improvements to this provision in the text of the European Parliament, so we highly encourage the co-legislators to adopt this specific position because it provides the protections that are needed there. But this risk would also, of course, extend to civil society organisations whose very aim and purpose is to address the societal and political ills that affect many communities. This is not to say, of course, that civil society organisations should be outside the scope of some of the obligations of the regulation, but this broad definition, as mentioned, would capture, again, this kind of non-commercial political content, and this is, to steal a term from my home country, the bread and butter of civil society organisations, holding to account those in power and advancing political progress. Therefore, the definition would also risk chilling the speech and the outreach of civil society organisations precisely in a time in which we see a shrinking space in civil society that needs to be addressed and not further hindered by regulation with unintended consequences. So this is also a risk to the right of freedom of association when you look at it from this perspective as well. But this brings me to another reflection on the proposal, and this is related to this issue of the definitions and how certain things are being conflated between one another. And I would be remiss if I didn't mention some of the ongoing conversations that are happening in the context of the negotiations, because it seems that there's also a slight conflation in the definitions when it comes to the different forms of communication that a political party may do, such as emails or direct communication with their members, and political advertising. It seems quite confused. And so when you're looking at the conversations that are happening around the data protection provisions and the scope, all of this begins to make sense when you understand there's a lack of clarity around definitions. And as Eliška mentioned, a lot of work has been placed into making sure this was quite clear. So it's disappointing to see that maybe the conversation is beginning to take a step backwards when really it should be moving much forward. So my final reflection on this is that the regulation and how the co-legislators set out to address the political advertising system cannot be characterized by an attempt to empower incumbent politicians to continue or validate the misuse of our data, especially sensitive data for political gain, nor can it be a vehicle to create parameters around regulating political speech, as this would violate international human rights standards and indeed the Charter. And lastly, as the negotiators are continuing their conversations, they must consider the quote-unquote Brussels effect and the impact of such a regulation would have if it were to be copied or referenced globally. Democracy is at risk both in Europe and globally. Therefore, setting such a precedent could have widespread repercussions. So we really hope that the co-legislators remember their duty to get this right and remember that their role is to protect our fundamental and human rights in this context and not to lessen them. Thanks.
Thank you, Asha. At this point, I think we have something like 25 minutes for Q&A. If anyone from the audience would like to step up to the microphone to ask a question, mentioning name if relevant, affiliation. Otherwise, I have too many follow-up questions for our panelists, but please, Fanny.
Thank you very much for all the presentations. I'd like to try to get you out of the Brussels lingo a little bit and the abbreviations, because I understand that, but I frankly don't understand one basic political impetus behind this. How is the European Commission and the Council telling us a message that it's not okay for private companies to use this data for commercial advertisement, while it's okay for politicians to use this data for political advertisement, which is an even more sensitive. If we had to, I don't want to choose between the two, but you could argue that it is something that would require a higher threshold, not a lower. So I just don't understand where the European Commission is coming on this. What's the objective if this is the result? Thank you.
If anyone else would like to ask another question, otherwise I think this is food for thought already for anyone in the panel willing to take it.
Okay, so, or maybe you would like to start? Okay, fantastic. So I think it's an excellent question and something we've been discussing on so many occasions. Indeed, again, civil societies as a part of the DSA debate, and in order to uphold the essence of the GDPR and the protection of privacy, pushed strongly for having that ban within the DSA that concerns targeting and the commercial targeting. When it comes to political advertising, it's very much connected to in what shape and what stage our democracies will be. And let's not forget that the European elections are right behind the corner, right? They're coming up in 2024. So to me, as I understand it, from the perspective of someone who's been working on this regulation, first of all, of course, there is a certain political momentum in preserving and defending this regulation, even though we could argue that from the very start, excluding political targeting or political advertising from a broader ecosystem of advertising and ad tech and all those harmful consequences for fundamental rights that this industry carry, maybe that idea wasn't exactly wise for the purpose and for creating this lex specialis regulation that we are now dealing with. And I personally find it absolutely outrageous and unjustifiable that the politicians do actually look for the carve-out from, on one hand, already existing horizontal regulation and the ban within that regulation, and at the same time trying to look for justifications why they should be allowed to use our sensitive data in order to effectively deliver their political messaging in the fight for European voter, while the independence of and integrity of the election should be the first and outmost priority for regulators and decision makers. So from that perspective, besides the political reasons, I find it, especially from the fundamental rights perspective and the Charter, almost unjustifiable why such a practice should be permitted. Now, there are a number of other arguments. We are hearing, for instance, that this is done due to the fact that some decision makers believe that the empowerment of civil societies organizations who in some parts of Europe might be dependent on targeting is sort of driving argument behind their justification why they want to defend these carve-out and the use of sensitive data. Respectfully, any civil society organization, and especially those of us who fight for the protection of fundamental rights, if we decide to target, we are happy to comply with the transparency criteria, and that goes without any questioning. But if I do my advocacy for the purpose of fundamental rights protection without touching or processing any data, and I do this as a part of my everyday activity, which we do on a regular basis, then there is no reason why I should comply with burdensome obligations that simply should not apply to us, which very much bring us back to the scope of the definition of political advertising, which is the outmost and the biggest issue as well as a part of this regulation. I'm sorry.
Anyone else would like to jump in?
Maybe I can add a very, very small comment. I think it's consensual, I hope so, even within the Council and the Commission, that we will not go below DSA rules in any type of circumstance. To be clear, this means that at least for online platforms that are not micro or small enterprises, profile based on the use of special category of data will be prohibited. But of course, we would like to go further if possible concerning political advertising. I would like also comment on an intervention that is very interesting about GDPR, but it's maybe other debate for other day, because it's very interesting to know how GDPR was affected by the progress of technology and especially the use of data and the way we face data nowadays, either to protect them or to use them. But it's another discussion. It's another discussion. Thank you very much.
Maybe, on the basis of what was just said and on the basis of Fanny's question, I can say, well, it's reassuring, first of all, that there is to hear that there is consensus not to go below what has been achieved in the DSA. But if ever there will be some afterthoughts in relation to that, and in relation to these afterthoughts, I can only react by saying, it's of course it's not for me to defend the Commission or the Council position, but quite the contrary, we advise the legislator and the Commission on what to do best. I think that lowering the level of the protection has some implications, most simply because we wouldn't need even this regulation to be there as for Article 12. Like GDPR already provides with its horizontal reach two exceptions to relevant exception for the context of political advertising. Namely explicit consent, but also the pursuit of legitimate activities for political aims for certain organization, among which political parties or groups, etc. So I would wonder, okay, were we even in this process of debating and making, engaging in a decision process on a political advertising? So to me, it's absolutely evident that we need not only to preserve what has been achieved in the DSA, but to make a step further. And I would say that, so not only there would be no even reason to engage in political advertising discussion if that's what some, let's say, counterparts had in mind, but what is questionable, in fact, it's been raised before, is the appropriateness of using this data for political messaging, how data about our sexual life could be relevant for political message. I really would love to hear a counter-argument there. But if I may, I think that at least my understanding of Article 47, of Recital 47 of the Commission's proposal actually already acknowledged that there are risks stemming from the use of this data, the misuse of this data, beyond, in a way, at least this is my understanding, beyond the breadth and the reach of sensitive data as such. And they explicitly refer to data also directly or indirectly collected from the users, which, by the way, brings into the fore a new, the new category, the different categories of inferred and observed past sources. So there are ins in what they propose already, which is quite interesting. So. Yes, I'll stop it here.
Interesting it is.
If I may, to come back to your question, Fanny, the only way I can put it simply is I think the quiet part is being said out loud. And that's why it's the work of civil society organisations is so important to not only hold private sector actors to account, but our politicians and governments to account as well. And I would draw your attention back to the mandate of the council, where there was a proposal to have a two-tiered approach in terms of where the obligations applied. So you might remember, or for some of you who may not know, there was a proposal to have government exemptions coming from the council before this was being discussed in terms of, okay, now we as political actors get to use sensitive data. So there were whispers, and at least some of this was coming in from a quite early perspective, and some of it was coming from concerns about the modalities of elections, right? There are some things that people need to know, where you need to go and vote, but this was already exempted in the Commission's proposal. So I genuinely think what is being negotiated, or at least discussed at this moment in time, is really facing the reality, and again, I'll go back to Brexit, of what has become common practice in many places already, and trying to create a regulation that unfortunately allows that to continue. And I would come back to some of the examples that have been made in regards to, civil society organizations and looking at the work and things like this. And I don't think the aim of the regulation should be to equal the playing field in which that playing field has been built on the misuse of our data already. The aim should be to stop it and address it. It shouldn't be about we all get to use the toys. That's not the purpose. But I would say for the work of CDT, we very much based our original opinion of this proposal on the opinion of the European Data Protection Supervisor. And if I may, I would just like to quote that opinion because it very explicitly says that it finds it very difficult to imagine any justification for collecting and processing data concerning, for instance, health, sex life, sexual orientation, or genetic data in order to advance political messages. It also goes on to say it doesn't think it would meet the measure of proportionality. So this is coming from, the most highest level expert opinion on this. So I'm also very confused as to why this conversation is happening, and the only justification that I can see for this conversation happening is that it's already happening, and that justification and validation is being given to the fact that it's already happening, and it's for others to hold that to account and shine a light on what is occurring in this context.
Thank you very much. If there is anyone else from the audience who would like to ask any question, there we go.
Yes, very quick question regarding...
May I ask for your name and affiliation?
Eleonora Nestala, researcher and lawyer. Just wondering whether you have looked at the interplay in the implementation of the regulation with electoral law at member states level, because this is quite a challenge. Political advertising isn't political campaigning. Political campaigning is highly regulated, a lot of specificity by member states. So just wondering if you have looked at it. Thanks.
We cannot interfere in electoral law of member states, and it's very important, as Asha said before, to separate, to make the difference between what is political debate and political campaign and political advertising as a service. And we are trying, on the opposite of the position of the Commission, we are trying to restrict this regulation to political advertising as a service. And like that, I think it's easy to articulate in fact with electoral political laws that normally regulate the debate and the campaign of the parties and other actors of the political campaigns.
I might moderately abuse my privilege as moderator here to say that my organization EPD, we're actually throwing a series of workshops across European capitals on this very issue. And one concern that we actually have, it looks very differently from country to country. So of course we will have harmonized European laws that interact very differently with very different national laws. Enforcement authorities diverge massively. Some countries have a single enforcement authority. Some countries enforce electoral law through 12, 15 different authorities. Yes, it's going to be something interesting to follow in practice, and it's going to give a couple of headaches, I'm afraid. Are there any more questions from the audience? I might then ask for the panel a question back on the line of the paradigms, and I think this discussion feels like a roller coaster in that we go from a second of the high hopes of introducing modern, up-to-date restrictions on personal data building on top of the GDPR that are quite exciting, thinking about political advertising and thinking about it as a precedent. And then we are raising all of the concerns of why are some pushing for actually weakening the protection under DSA. Why are we seeing certain things we're seeing that we don't even understand and are often, as I think rightly pointed by Asha, argued in private but not argued publicly. But another idea that has been floated privately and we know of because of leaks in media such as Politico and Context is that the council is putting forward an idea of splitting the category of personal data. So say something like, we should allow the use of certain special category data and not of other category data. So we shouldn't be able to target political advertising to certain people on the basis that they are sick, that they may have cancer, but we might be able to target political ads to someone on the basis that they are Muslim or Christian. Mm-hmm. How can we think of a regulation like this on political advertising to review, revamp, challenge, shatter the category of a special category data as a set of a closed list to open it up and regulate different special category data differently?
Maybe I'll start because realistically I have the shortest comment in the panel. As EDPS, we've looked and commented on the use of sensitive data as a uniquely relevant category. So we haven't differentiated, we will not differentiate it. And as Asha was very nicely quoting, we see no justification, as simple as this, for using special categories of data for the purpose of advancing political messages, because this will fail the necessity test. So I think that's everything I have to say on this idea. Thanks.
I think that summarized it all. I think that all of us would very much agree with this statement.
So at this point, unless there are any other questions from the audience, I think we will wrap up. I think definitely the conclusion from the discussion is,
There is.
Yeah, I do have a question.
Name and affiliation, please.
Yes, Colin Bennett from the University of Victoria in Canada, and I worked on the Council of Europe guidelines. The root of the problem here, in my view, and I must say I'm not intimately familiar with this, is making an appropriate distinction between political engagement and political manipulation. And I'm with you on terms of preventing political manipulation. But to your point, practices vary from country to country. And what is considered appropriate political messaging in one country might be very different in another country. It may be very different in terms of the engagement that individuals have with their political representatives. And I was thinking of the implications of what you're saying about consent. Is it really the case that if you're engaging with a political actor and saying you're engaging in terms of sensitive data, say, you're in an LGBTQ community and you really do want to have that messaging, you really are interested in what that political actor and what those political parties have to say on a policy that you're deeply, deeply interested in. From what I'm hearing here, I think that there's a danger that you go over the top in terms of in regulating the political manipulation, which I'm perfectly with you on and I think needs to be stopped. But at the same time, you're preventing genuine political engagement, which allows for political actors, political parties, indeed, to provide messaging to those people, maybe on some very sensitive issues, including race, including ethnicity, including health, including sexual orientation, which they might want to know about. That was the struggle that I had when we were doing the work on the Council of Europe Convention. So I just wanted to put that out there.
Who wants to pick up on this?
I think this is a relevant question and remark, but maybe there are alternatives to send this kind of message to some kind of voters and electors or political participants.
But that's my question. What is that?
Sorry, you will not.
Sorry, that's my question. What is the alternative? Am I clear?
Yeah, and it's not this is of course the argument that is being or has been raised before, but I personally maybe fail completely to understand, or I'm questioning whether we overestimate the necessity of the use of sensitive data such as sexual orientation or religious conviction in order to make one's political message as effective as, you know, some political actors or all political actors seek to achieve. I do believe that there are other means and communication tools where those messages, especially for these communities, can be actually made equally available and accessible in democratic societies without necessarily making them more vulnerable and letting bad actors or those who seek to ultimately manipulate independent elections to exploit those vulnerabilities. I am absolutely against the idea that there should be any distinction or categories within sensitive data of sensitive data. And at the same time, if the text that is currently on the table, especially coming from some EU co-legislators, would remain intact, this is very much playing with people's sensitive data for the political gain. And then, of course, it is important, and I think we did not properly address it at the beginning, it's also essential to establish proper distinction between targeting and ad delivery techniques. Because, for instance, with ad delivery techniques that are purely usually automated systems that process enormous amount of data, and that was also emphasized by the European Data Protection Supervisor in the past, this does impose inherent risks and gives almost no proper tools or means or even meaningful transparency to those who are being targeted to actually have an understanding how these systems work. And there, the abuse of sensitive or then inferred data that can also be sensitive data can really cause enormous damage that can go into issues such as mental well-being of communities and individuals. So maybe we overestimate the use of sensitive data for this purpose by political parties.
Sorry, if I may, I think, and I hope I'm not misunderstanding your question, but it raised another question for me in terms of what do we mean by political manipulation and what do we mean by political advertising? And this goes back to the purpose and scope and definition of the regulation, right? So this is a regulation that is intended to deal with commercial content. This is sponsored content. This is a very specific thing, and we're talking about the use of sensitive data in that context. And I think we would all agree there should be no level of use of sensitive data in that context. I can't even imagine having a list where it's set to say it's okay to use ethnicity but not health data. That it just boggles my mind. So what I think the question that you're bringing up is actually something that's better addressed in a kind of multifaceted framework, right? So I would look also to the risk assessment provisions of the Digital Services Act, where there will need to be annual risk assessments on impacts to civic discourse and democratic participation, right? We have the Code of Practice on Disinformation, for example. We have it's about the interplay between those frameworks when I think we're talking about political manipulation over political advertising. And for me, there's a distinct of course, manipulation can happen in the context of advertising. I'm not disputing that. But I think that more holistic kind of macro level term needs to be dealt with in a more multifaceted way. And I would go back to the point that Eliška brilliantly made about the use of this information by bad actors, right? So I don't have a direct example from the European context, but from the Anglo context I do, in which ethnicity data was used, for example, to target with sponsored content to say, go and vote on this day, which was the wrong day, in order to eliminate ethnic minorities from participating in elections. I would have a concern about how such information is also being used by bad actors as well. So I don't think there's no appropriateness around this, but it brings me back to that question of the scope, the definition, and how we address something as broad as political manipulation, whilst also respecting the fact that we have to balance rights and protect political expression, freedom of association, and the right to relevant information in elections.
Thank you.
Well, just to say that Colin's question, and thanks very much for that, and the further engagement made me reflect also on the fact that we will probably need to bring, and I haven't been quite explicit actually on the core of our recommendations at the EDPS in relation actually to this file. We will need to bring a further element that was briefly mentioned on how, in fact, the problem is how the ecosystem works, and to really bring to the table pervasive tracking and such. So there is a problem with, surely, with data, with sensitive data, which could be used for political messaging. But the hugest problem, I would say, is about pervasive tracking. So what we haven't said is that the vast majority of data relevant for this ecosystem is in fact indirectly collected from the user and is in fact either observed out of the of the behavior of this person or built in fact by the controller, let's say, on the basis of observed data. So this data, which represent really the essence, I would say, of the tracking, of the pervasive tracking, which is pervading this ecosystem. And that's where, as EDPS, I wanted to conclude by saying that we call for a ban on micro-targeting and especially on stopping pervasive tracking. So I think this element should be brought to the table as well. Thanks.
We are being asked by the organizers to wrap it up, so that I will do. I do really believe from the interventions, and thank you very much for all participants that contributed, that indeed this regulation would represent a change of paradigm, but not a new change of paradigm that we have had already, and that we shouldn't be afraid of that. Let's hope that in 1 or 2 years we can reconvene here and discuss the merits of this regulation in practice and whether it has solved any of the problems it seeks to address. Thank you very much to all of you. Thank you, Eliška. Thank you, Anna. Thank you, Maria-Manuel. Thank you, Asha. And thank you, everyone, for your time and participation.
Small remark to say this is not usual, a panel discussing technology and data only with women. But